My lords, I appear on behalf of the appellant, Mr. Yahya Rashid, who was convicted at the Crown Court at Woolwich of two offences under Section 5 of the Terrorism Act 2006 and received a sentence of 5 years imprisonment. Mr. Rashid appealed against his conviction, and this was rejected by the Criminal Division of the Court of Appeal on the 18th of January 2017. My lords, the present appeal is concerned with one of the three grounds that were rejected by the Court of Appeal in its decision. Specifically, the Court of Appeal rejected my client's contention that based on the evidence, the judge should have directed that an intermediary should be present throughout the course of the trial and not just for the duration of my client's evidence. My lords, it is my submission that Mr. Rashid did not have a fair trial in light of the fact that an intermediary should have been made available throughout the trial, as he could not otherwise access all the relevant information that was delivered. Mr. Rashid was a vulnerable individual, truly unable to understand the criminal proceedings he was facing, and particularly the evidence presented by the prosecution against him without the assistance of an intermediary. It is my submission that Mr. Rashid was denied of the right to a fair trial to which he was entitled. Furthermore, the suggestion made by the Court of Appeal that no arguable point had arisen in terms of justifying the provision of an intermediary for the duration of the trial is frankly unsustainable. My lords, it has long been established that anyone charged with a criminal offence has the minimum right of having the assistance of an interpreter in order to understand the language used at court and the evidence given. In the case of Kunath v. the State, the Privy Council held that it is an essential principle of the criminal law that a trial for an indictable offence should be conducted in the presence of the defendant. The basis of this principle is not simply that there should be corporeal presence, but that the defendant, by reason of his presence, should be able to understand the proceedings. My lords, on the basis of the expert evidence presented at trial, it is undisputable that Mr. Rashid did not possess sufficient intellectual capacity to comprehend truthfully the evidence presented against him. While Mr. Rashid did not need the use of an interpreter, the lack of assistance of an intermediary for the whole of the trial entailed a blatant conflagration of Mr. Rashid's right to a fair trial, and therefore it is our submission that Mr. Rashid's conviction is unsafe. My lords, Mr. Rashid was denied of this basic human right. The ruling by the judge that an intermediary was only required when Mr. Rashid gave evidence disregarded the finding agreed by the experts that Mr. Rashid had a cognitive ability that was described as low. The judge erred in his consideration that Mr. Rashid did not require an intermediary throughout the trial on the basis that he did not suffer from a learning disorder or a learning disability in accordance with relevant applicable law on mental health. In effect, the judge erroneously ruled that Mr. Rashid did not qualify for special measures under the Criminal Practice Directions 2015, and in doing so, denied Mr. Rashid the invaluable assistance of an intermediary who would have enabled him to understand the trial proceedings in full, as well as engage with his defense. The judge incorrectly concluded that Mr. Rashid had no significant impairment of intelligence, contrary to the evidence of extremely low, or at very least borderline low cognitive ability presented by the experts. Not only was the decision to restrict the use of an intermediary to assist Mr. Rashid unfair on the basis of the evidence available at trial, but also morally wrong and contrary to human rights law, as Mr. Rashid was thereby denied of a fair trial. My lords, the Law Commission has recently recognized the difficulties encountered by vulnerable defendants who are unable to engage with the criminal process in light of their mental or physical condition. Further, the current law was described by the Law Commission as outdated, inconsistently applied, and leading to unfairness. My lords, the decision of the trial judge in this instance is one such example. While it was apparent that Mr. Rashid lacked sufficient ability to engage meaningfully in his trial, the judge refused to allow the presence of an intermediary throughout the proceedings for no reason other than his own views, and consequently denied Mr. Rashid of a fair trial. My lords, the Court of Appeal was equally wrong in considering the approach of the judge as correct, particularly when the judge deviated from the agreed conclusions of the experts and used his own observations as the basis for rejecting Mr. Rashid's request for an intermediary throughout the trial. In effect, the Court of Appeal failed to acknowledge that it was not for the judge to determine the cognitive capacity of my client when this meant to disregard patently the evidence presented to the court. My lords, this further corroborates that Mr. Rashid did not receive a fair trial, and by denying access to an intermediary throughout the trial, the judge failed in its duty under its inherent powers to assist Mr. Rashid to participate fully in this trial, especially in the light of the robust expert evidence that the presence of such an intermediary was necessary in Mr. Rashid's circumstances. My lords, the decision made by the judge to deny Mr. Rashid the appointment of an intermediary throughout his trial appears so defiant of logic in light of the expert evidence that was made available to the judge. As a result, did the judge openly fail in his duty, both under the common law and the criminal procedure rules, to ensure Mr. Rashid received a fair trial, as the appointment of an intermediary throughout the trial was clearly necessary in the circumstances as well as on the basis of the evidence. The appointment of an intermediary goes beyond the mere power of the court. It is an intrinsic duty of the court to ensure the defendant receives a fair trial, as was established in RV Seven Oaks Youth Court. My lords, the point made by the Court of Appeal at paragraph 75 of the judgment that R.V. Cox shows that the appointment of an intermediary is by no means mandatory seems unfounded. In effect, the obiter comment made in R.V. Cox that the Court of Appeal refers to in relation to the fact that judges are expected to deal with communication problems faced by the defendant is inapplicable to the facts of the present case, as not only that would be impractical, but also unfeasible in the context of criminal proceedings, particularly as the judge may be unaware the defendant is experiencing difficulties following the trial. My lords, the Court of Appeal further refers to RV Ministry of Justice at paragraph 76 of the judgment. Circumstances in that case were far from similar to the case before your lordships today. The court was not persuaded in that case that it was essential that an intermediary was made available to the defendant for the whole duration of the trial. While it might not have been essential on the basis of the specific circumstances of that case, the comment made was by no means authority of the requirements of the appointment of an intermediary. On the contrary, what makes Mr. Rashid's case different from RV Ministry of Justice is that the evidence before the judge indicated that it was indeed necessary to appoint an intermediary throughout the trial, and the judge flagrantly and unlawfully disregarded it, thereby denying Mr. Rashid of his right to a fair trial. My lords, the contention of the Court of Appeal at paragraph 81 of the judgment that the provision of an intermediary is a remedy for the potential lack of competency of any of the trial advocates is unreasonable and unfounded. The Court of Appeal implies that the appointment of an intermediary would result in substantial additional cost on the administration of justice when competent advocacy should be sufficient. This submission is so devoid of all logic as it seems to attempt to discharge the duty of the court to ensure the defendant receives a fair trial, in this case through the appointment of an intermediary throughout the proceedings by shifting responsibility to the trial advocates. In effect, in R.V. Cox, the Court of Appeal stated that it is for the intermediary to intervene when it is likely that miscommunication has occurred or is occurring. It is puzzling for the Court of Appeal to expect even the most competent advocate to intervene to remedy any miscommunication in the course of his or her own submissions, even if such potential miscommunication has come to his or her attention. My lords, as a result of the lack of an intermediary throughout the proceedings, Mr. Rashid was unable to engage fully in every aspect of his trial. It is our submission that the decision of the judge to restrict the appointment of an intermediary to Mr. Rashid's evidence is an abuse of process in the light that safeguards remained insufficient to allow him to participate effectively in his trial as established in R.V. Cox. My lords, on the basis of the expert evidence which was conclusive in that Mr. Rashid's level of intellectual ability, but which was disregarded by the judge, it is our submission that appointment of an intermediary throughout the trial was necessary to ensure that Mr. Rashid received a fair trial. It is therefore our submission that Mr. Rashid did not receive a fair trial, and hence his conviction is unsafe. My lords, the appointment of an intermediary throughout the proceedings to assist Mr. Rashid understand proceedings and fully engage and participate in his trial is further consonant with long-established jurisprudence of the European Court of Human Rights. In effect, in T versus UK and V versus the UK, it was held that at all costs, Article 6 guarantees effective participation of a defendant in the trial. The decision of the Strasbourg Court further strengthens the role of the court in respecting the most fundamental and absolute rights of defendants. Furthermore, as well as the right to participate effectively in his criminal trial, Mr. Rashid, a young adult, not a child, should have expected to understand every point of law or evidential detail at issue throughout the proceedings to ensure his right to a fair trial was protected, as established by the European Court of Human Rights in the case of SC versus the UK. My lords, the overriding objective that criminal cases are dealt with justly also includes Rule 1, Section 2C, which recognizes the defendant's rights, particularly those under Article 6 of the European Convention of Human Rights, in relation to which we have made submissions. Moreover, under the criminal practice directions, the court must by any appropriate means make sure that the defendant understands what is happening and what has been said throughout the proceedings, not just in the course of his own evidence. The overriding objective would certainly not be achieved if intermediaries were not appointed when necessary in a quest to save costs for the criminal justice system. My lords, in view of the foregoing submissions, Mr. Rashid's conviction remains unsafe. May your lordships grant this appeal and quash the Court of Appeal decision of 18th January 2017.